father ran a research lab.
Oh, here's your friend.
I think you know who it is.
At UNC.
Where's he looking at us from?
My parents moved there after I was grown up, but I still like to come down.
It's not his control room.
I could very easily.
Okay, we want to start.
Everyone told me I had to. I live in Durham, but I actually border between languages. I don't go there.
I'm good.
Were there no cookies? Oh, that's a bummer. We got to have cookies. Welcome to the final session of the day. Happy Privacy Day, everybody. I'm Richard Purcell, Corporate Privacy Group. We're going to be talking about international data transfers today, cross-border transfers. You've heard a lot about that today. You've heard terms like safe harbor. We heard a little bit about PNR. The whole question comes down to what happens when you transfer information across jurisdictional boundaries. We have a great panel, and I'll be introducing our panel as we discuss the issue. I'll refer for their full bios, which I encourage you to read in your packet. But we're not going to do the 10 minutes each, speech. We're going to have a conversation, and we hope that you'll join that conversation as well. Now, we were encouraged in the earlier panel to tell stories, so I challenged my panel members to tell stories in order to illustrate the issues. And in order to start that off, I want to set the stage here and tell a story about a primordial event that happened in the mid-90s. Long ago and far away in the empire of Windows, William the Geek knew that there was a serious issue, and by adhering to the law of Moore, he managed to extend his empire dramatically. Now, William the Geek was recognized as a very smart man, but as his power increased, his magic ball became cloudier and cloudier. He had a very dim view of what was happening as his empire stretched further and further away. And the reason was because he had scrolls and scrolls and scrolls of information written by many different people in many languages, and it didn't make a lot of sense to him. He had information about his serfs, he had information about his peasants, and he had information about all the guild members that he worked with, but he couldn't quite connect all of this information into any kind of realistic whole. So he was very frustrated, and the rocking began, and there was no smiling. He turned for help to his most handsome and wise advisor, Richard Longtail, who he hoped could help solve this problem. And the problem, of course, is there's too much information in too many places, scribed by too many different people in too many different ways and languages. Well, Richard visited the far-off lands in order to try and figure out what to do about this, what the solution would be. And so he visited the land of Peter the Tall and Stefano the Wizard and asked them about how could this work? How could we bring more information in a more efficient way to William the Geek so that William could extend his power? Well, Peter the Tall and Stefano the Wizard said, we're not like you. And we have rules that are different. And in fact, we have issues around trusting William the Geek and his extension of power. And in fact, we have a cooperative kind of universe here. And so Richard visited others, including Marie the Formidable. We found from all of these visits that these rules that were not working together very well, kept William the Geek from getting the kind of information he wanted to get, and yet he was planning a worldwide web of information at the same time and a way to get that information. And so we began to work with the others who had trust in one another to formulate a set of rules by which this web of information then could begin flowing freely, and serfs and peasants and guild members' information could flow in a free manner back and forth. That really was the condition that we were in, and it was a very threatening condition in many ways to a lot of commercial enterprises in the United States particularly. William the Geek is, of course, an apocryphal example. I'm sure you don't understand at all who I'm talking about. The issue, though, was very, very, very important to all players, and a lot of people began to work very hard on it, including our Department of Commerce and our European friends and colleagues. And they began to understand one another's language, and they began to exchange information, and as happens when people actually sit down and talk with one another, they began to feel each other's pain. And I want to introduce Damon Greer. Damon is works at the Department of Commerce's Office of Technology and Electronic Commerce, and is the director of their Safe Harbor program. The Safe Harbor program is one way that this data is allowed to flow. And I wanted to ask Damon, what happened and how did it come about, and what is the status of that? And additionally, what are the other mechanisms that may be available in addition to Safe Harbor?
I was going to tell a story as well, but mine isn't as interesting. But it is a real-life experience. It's an anecdote of data flows, but it takes place on a ride-on bus from the Bethesda Metro stop on my way home. And this happened about 3 weeks ago. I was minding my own business, reading a book, as I usually do, and there were two high school students sitting behind me. And one of them called a friend of hers on the phone, and there was a crisis. The girl on the other end had just been thrown out of her house by her mother. She had to pack up all her clothing, and her mother threatened to ship her back to Russia, and where they had just recently immigrated from. So the girl was distraught. She called her father, told her father the address of the girl, and asked her to pick the girl up. Her father said, well, I need to talk to your mother first, and why don't you come home, and then we'll all get in the car and go over there and see what's what. Meantime, all this information is passing back and forth between the girl and her other friend on the bus, and I couldn't help but wonder, are people aware of the kind of information that they're passing on, be it in a commercial bus, a subway station, a taxi cab, or what have you, when they're talking on the telephone. Fortunately for her, her battery in her cell phone died, and she could no longer pass that information on. So I thought that I'd throw that out there only as a point of showing that people are responsible for what they do just as much as businesses and governments are responsible for what they do. Now getting back to the question, Safe Harbor came about as a result of the implementation of the Data Protection Directive in 1998. It was enacted in 1995, and member states had 3 years to implement the directive with national laws and establish data protection authorities. From what I hear, this caught us unawares here in the United States. I wasn't in Safe Harbor at the time, and immediately we entered into negotiations with the European Commission to come up with a solution that was amenable to both privacy frameworks, but did not mirror one over the other. And as a result, we have what we call the European Union Safe Harbor Framework. The framework consists of 7 privacy principles that are derived from the OECD principles, as well as the provisions in the EU directive. They are, I hope I can remember these, notice, choice, access, onward transfer, data security, data integrity, and enforcement. There's 7 of them. Our colleagues from the Federal Trade Commission provide the enforcement mechanism along with the Department of Transportation for airline ticket agents and what have you. The enforcement comes from the voluntary commitment that companies make when they sign on to safe harbor and post privacy policies that have embodied in them a commitment to adhere to the principles. It's a voluntary commitment, but once you sign on to safe harbor and agree to follow those principles, it's binding. And that's where the FTC can investigate any complaint that is referred to us by third-party dispute resolutions mechanisms. These are independent third-party entities that will mediate any dispute that cannot be resolved internally to the company. The premise upon which safe harbor is based is that companies have a vested interest in resolving any disputes because the disputes that may arise from potential customers or existing customers need to be mediated and resolved because the United States has a long history of providing customer service and to keeping the customer satisfied, unless you're on United Airlines, and Joe can speak to that. And as was mentioned earlier in a previous panel discussion. So having said that, safe harbor, I think Peter Hustings mentioned earlier in his presentation that safe harbor is a transatlantic bridge across the Atlantic. At a time when data transfers were actually physical transfers and they were carried on electronic media data tapes, 3.5-inch discs, CD-ROM drives, and what have you, today it's a different ballgame. It's all about access. Information can be accessible instantaneously anywhere in the world, and the data doesn't necessarily have to flow as it were from one point to another point. It's accessible from multiple points at any given time. So when we talk about safe harbor, companies more and more often view the framework with that in mind. And as a result, we're having a lot more interest in companies joining safe harbor because their European partners demand that they do. They're involved in e-discovery, providing forensic services in the course of litigation, and there's a lot of pretrial activity and discovery, and we're seeing about 2 companies a week join that provide those kinds of services. We have about 1,400 companies in safe harbor right now. We're adding about 30 a month, and they run the gamut from heavy industry to IT services to legal and pharmaceutical, clinical clinical trial services as well. What we don't cover financial services. We don't cover telecommunications, common carriers, insurance companies, or nonprofit institutions. These organizations, for a lot of different reasons, were excluded during the original negotiations, and I think Leonardo can speak to that. He was involved in those negotiations way back when. And we have a few things that we're trying to do to make safe harbor more visible. We have a seal coming out that we will be awarding to each company that signs on to safe harbor and maintains their status to give them the visible recognition that they could use on their websites or in their literature, with the proviso that they have to keep their status current, they have to reaffirm every year, and if they don't, then other sanctions could apply. I think that's all I have.
Cool. Now, Damon, one of the things you said was that financial services are outside of this safe harbor umbrella. Tucker Campbell is a senior VP at Wachovia. I wanted to ask Tucker, okay, so you don't have safe harbor as one of your ways of doing this, so that just means you can't transfer any data from the European Union to the United States. Is that right?
Not quite, but it's a lot more complicated than it would be otherwise. And I don't have any fractured fairy tales to share to sort of introduce us, but But in support of Ann's comments earlier, I will add that when our privacy notice comes to our house, I can't get my 10-year-old or 13-year-old to read ours either. The issue we have with financial institutions is that for the safe harbor, in order to be eligible, you have to be subject to the jurisdiction of a government body which is empowered to investigate complaints and to obtain relief against unfair and deceptive trade practices in case of noncompliance with safe harbor principles. Now, anybody who's spent time with the kind of diversified financial institutions knows that we have OCC, the SEC, OTS, Federal Reserve, and any number of federal regulators spending a lot of time trying to do exactly what's described in that sentence of investigating complaints and making sure we're not engaging in anything unfair and deceptive, as well as a whole number of other things. In fact, we have the pleasure of having several of these agencies with offices within our offices, making sure we're paying close attention to safeguarding rules and privacy rules. Nevertheless, the safe harbor agreement has reached conclusion that only the Department of Transportation and the FTC are empowered to enforce the safe harbor. So that leaves the laundry list of industries that Damon had mentioned out of this particular process. So what that leaves us with is sort of a combination of you can either follow the model contract process or you can get consent. And for financial institutions, both of those present some obstacles and issues. There's been some discussion already about the consent process of, when is consent really consent for an employee? We have tried to work around that by getting the consent at the application stage, as opposed to once they're already on board. It's a better argument at that point, but I'm sure our European friends would maybe have some other views on that. And then you still had the remaining issue of consent can be revoked at any time and have to have a way of managing around that. So we do get consent from our employees, recognizing that's part of the Band-Aid for us. There's also the model contracts that you have for being able to transfer data from Europe back to the U.S. For banks themselves, that presents another sort of novel issue of, for branch banking, you have the same legal entity in certain cases, which is in the U.S. and in London. So you have this sort of odd process of contracting with yourself to represent your protecting data and the ways that the EU directive and the safe that would like you to have you protect information. So where it's left us is with these sort of Band-Aids of they're mostly compliant, maybe not quite as compliant as we'd like them to be, but we're making our best efforts to get data back and forth in the right way.
Cool. So is your experience at Wachovia similar? Do you know what the other financial sector entities are doing? I mean, is it as complicated for them because it's the same jurisdictional mess? You've got jurisdictional or regulatory oversight in the United States, but you also have regulators in the other countries that you operate in as well.
Yeah, that's right. I mean, we have, Wachovia is principally the principal operations are in UK and in Hong Kong, and we have the FSA in the UK also examining us, as well as the Hong Kong Monetary Authority in Hong Kong. Other institutions, I think, are basically in the same place. There's interest in, can binding corporate rules work at some point? But for the financial institutions, we're not, don't have quite the same international presence with personal data that it's worthwhile for us yet trying to pursue binding corporate rules because it's a fairly laborious process. A few companies are pursuing that, like GE at this point, but we're don't quite have the concentration where it makes sense for us to pursue it yet. We may spend a little more time talking about.
So we got safe harbor, we have model contracts, we have binding corporate rules, and we have consent, but we're not going to really depend on consent very much or very well. I want to introduce Jane Horvath. Jane is the Senior Legal Counsel for Privacy for Google, and we'll get to that. But for the moment, I want to point out Jane's role previous to Google as the Chief Privacy Officer and Civil Liberties Officer for the Department of Justice. She was the first person to serve in that capacity at the Department of Justice. And at that time, Jane, as I remember, you were involved as part of the team to try and figure out how government-to-government information sharing was going to work out across borders for law enforcement purposes. Now, we heard earlier from our esteemed professor that the PNR data had a very long and tangled saga, as you described it. How did that process work from your experience? Not the PNR side, but the more general side of information sharing for governments.
I can tell you a story as well about the birth of the high-level contact group. About September of 2006, we had just finished negotiating the temporary PNR agreement, and it was quite exhausting. I think the final negotiation kept our European counterparts up till 3 in the morning, which was not the best way to end a negotiation. And I think all nerves were frazzled on both sides of the Atlantic, and there was a recognition that data protection was really hurting the law enforcement relationship. We had law enforcement professionals negotiating data protection principles. And the real fundamental problem is in the U.S. Privacy Act, which actually in the U.S. government, we do have a privacy statute that has incorporated the Fair Information principles. However, the Privacy Act only applies to U.S. citizen data and legal permanent resident data. So it excluded out European data, left a big gap, therefore the need for the PNR agreements to ensure that that data would be treated adequately. So a number of us in the privacy area within the government thought that, there had to be a better way to do this than these late-hour negotiations and things that there was a lot said in the media, a lot of conspiracy theories, et cetera. There had to be a way to settle this issue. We were grown-up democracies, and we needed to be able to come up with an agreement that would cover transfers of data similar to the safe harbor in the commercial sector. So what we proposed prior to the Justice and Home Affairs Ministerial was creating a group to explore common principles of data protection between the U.S. and the EU with the hope at some point of coming to an agreement that would take the place of the PNRs and the SWIFTs and would give the Europeans the peace of mind that their data would be treated as Americans' data would be treated the same under basically the Privacy Act standards. And to be honest, it was really very, very difficult to leave. I was the lead of the experts group, and I also sat on the high-level contact group. And that was probably the one area that was the hardest to leave when I was offered the job at Google, because I really wanted to see it come to a successful end. And I'm pleased to report that I think the negotiations are ongoing, and I think they've made tremendous progress from what I've heard.
So we've got safe harbor for those companies that are under the jurisdiction of the Federal Trade Commission. We've got model contracts and binding corporate rules for financial services organizations. And we've got an ongoing, but maturing, hopefully, negotiation for government-to-government sharing for law enforcement. It's a mess in many ways. And there will be an effect. One of the things that I've heard as a recurring theme during the day is that technology doesn't sleep, and it'll mess up anything you do pretty soon. David Hoffman is the Chief Privacy Officer, Group Counsel, something like that, for Intel Corporation. And I was wondering, David, what the effect, how does technology affect this from Intel's point of view? And then, and looking forward, what do you think technology is going to do in the future about this?
Thanks, Richard. So, you're a fiction guy, and I'm a historical nonfiction guy. So I'm going to do my best here, but being a historical nonfiction guy makes it a little bit more difficult to keep everybody awake, I think. But we'll do our best here. I think what I've been hearing all day long has been a series of statements that it could be summed up to be something like, things are so different now because of the internet. And I think before that it was, things are so different because of databases. Before that it was, things are so different because of computers. Before that it was, things are so different because of television. Things are so different because of automobiles. Things are so different because of radio. Things are so different because of the printing press. Technological innovation happens, and I'm not going to say that the rate of technological innovation is not faster now than it has been in the past, but I think it's probably a truism that every generation thinks that the change that's going on in their generation is much greater than any generation has ever had to face before, and that the problems are much more profound. So one of the things that I've enjoyed doing is looking a little bit at the history of how some of these issues have developed over time and trying to extrapolate some of the things out that we can learn from to develop better processes. So just real briefly, I'm going to say there's been some fantastic academic work, actually, in the history of privacy in ancient Jewish texts, actually. And if you look at some of that, I think it's instructive. And this gets back to a tie to your story about Windows, that one of the early, yeah, that's the reach, isn't it?
I don't think this is rehearsed either.
It shows, huh? No, one of the early texts points out that when the tribes were nomadic, there were principles set in place so that when tents were set up, the tents were not allowed to have openings that would face each other. Well, then there was a great societal change when the tribes stopped being nomadic and instead started constructing buildings. And this was a huge technological innovation, changing the way people lived. And with buildings, you had people fixed in one space, so they needed to apply new rules, and so they made rules about where windows could be put and how windows could they face each other among neighbors. To me, I find that to be very instructive, because what has happened there, and I think happens in many other situations, is that there are core principles that are looked to, and then they're looked to how can they be applied in the situation with the new technology. And with new technology, I think what we're talking about is not necessarily how are they going to be used, although that is a place that we primarily want to focus, but also how can we design in privacy. So I want to talk about, we talked about it's not completely a new issue. I also want to talk about how it's timely, and then we can build on it. I want to talk about two specific types of technology that are creating a lot of issues and a lot of discussion. The first is social networking websites. And when I say timely, I want to talk about last week. So many of the folks probably know in the room that a student at Wake Forest was arrested for statements that were put on his Facebook page that people thought, I think rightfully so, were threatening and very concerning. Among with many of the other good things about social networking and about good things potentially about the internet in general, being able to use a tool potentially to find someone who is going to injure someone else is a wonderfully productive thing. What we've also seen very recently with social networking, that a lot of concerns, we've seen concerns with the state attorney generals investigating and reaching an agreement with MySpace. We've seen concerns with Facebook and with their Beacon program. And I think these are illustrative of some of the challenges that we face of getting out and educating people on the issues and helping people, but also designing in, that's what the MySpace investigation agreement is about, designing in privacy. So I want to take just a brief second. I think that's really what Privacy Day is about, to recognize these things. And I want to thank three people for the efforts that they've put in trying to get out to schools, developing materials. I want to thank Jolynn Dellinger, Kimberly McNeil, and Sharon Peters for all of the work they did to develop this and to move this forward. So then coming back to the international aspects of this, I want to get to the second example, timely example, which is unique identifiers. Peter Shar, the head of the Article 29 Working Party, just recently testified at the Civil Liberties Committee of the European Parliament. And what he said in the hearing there has been received a lot of press coverage here. And the press coverage says that Peter Shar said that IP addresses are personal data. Now, I was a little bit surprised about that because I've talked to Mr. Shar several times about this, as I've talked to a bunch of his peers and other members of the Article 29 Working Party, and it's a much more complex issue. So I did about much more reading and found out that that's actually not what he said. My understanding of what he said, and there are people who are in the room who can correct me if I'm wrong, was that he said IP addresses are personal data if they identify an individual. And then I think he went on to say that in many situations he believes that to be the case. I think this gets back to what I was saying earlier. You know, we're talking about applying principles that have already been articulated. What is the definition of personal data to the new technology and the way that the technology is being used? We have a lot of unique identifiers in hardware and software. This is what my company does, is innovate in new areas in this. With IP addresses, MAC address, RFID tags, trusted computing certificates, they're all there. We work to try to design in, but I think what we're going to need as an international effort as part of data transfer, because a lot of these technologies allow for the data transfer, not just centralized from, we'll take a bulk transfer all the way back to the United States, but globally, all over the world, point to point. We're going to have to figure out ways to design in processes. So when we do the identification of what is personal data, we know how to handle it appropriately.
So, Jane, I could Google about IP addresses all I want, but I might as well just ask you directly. Having joined Google as a senior counsel for privacy, IP address seems like one of the keys coming up in the future. We've danced around the issue for a number of years, but it seems to be freshening as an issue that of great importance. So what's Google's take on IP address, since that's one of the key elements that you have available to you?
I spent my Monday, my Martin Luther King Day, watching 3.5 hours of the European Parliament hearing. And I think what Peter Shar said was really nothing new. He did say if a person can be identified by an IP address, then that address is private. And the news reports then, of course, said Google disagrees with this. Google believes that IP addresses are not personal information. And I think that the answer is much more nuanced than that. I think we can agree that where an IP address identifies a unique person, then it is personally identifiable information. Now, I'm going to draw on both my Google experience and my experience working with the FBI and working the data retention issue that we were examining while I was in the U.S. government to talk a little bit about when does an IP address identify a person? How easy is it to track an IP address back to an individual? With respect to Google, if you are using Google as a quote-unquote anonymous user where we're only collecting the IP address, you're not logged on to your Google account, we collect your IP address. That IP address would identify maybe a computer, but it also may identify a network, an ISP. Why is that? Why is the case? Why is it hard? Why is it not just identifying a computer? The problem is there's a shortage right now under IP version 4 of IP addresses. So the ISPs that have been issuing IP addresses have had to think of different ways to manage the shortage. One of the ways that they have used is something called, I have really scribbled notes because David told me we were going to bring this up and I wanted to make sure I had a thorough answer. It's network address translation. And a lot of private networks use this, whereby you have internal IP addresses within your company that are unique. But once that network goes out, that host goes out, it goes out as a single IP address. So you've got law enforcement. Law enforcement knocks on Google's door and says, hi, I've got this IP address. Tell me whose computer used this IP address. We can't tell you whose computer. We can tell you geographic location because the IP address does point to a geographic location, but what we would have to tell them is to go to the ISP. Now, so they knock on the ISP's door and they say, tell me, who owns this IP address? The ISP will say, well, what date and what time? We may be able to tell you. We may not, depending on how good of records we keep, depending on how long we retain our data, depending on whether we have static or dynamic IP addresses. And we'll never be able to tell you who was sitting at the machine. We'll be able to tell you what account holder is paying the bill for that IP address. So I'm not arguing with the fact that an IP address could be identifiable information if and when you can identify the person that's using the IP address.
So as an example, I go to a kiosk here in the law school and use that. It will transmit an IP address, but it will absolutely not transmit my identity associated with that address because anybody who uses that machine may have the same or a similar address. A machine has a lot of addressable elements, the NAT, the network address translation, the IP address, the MAC address. There's lots and lots of identifiable markers, but they're not necessarily reliable markers for identity. They are really session-bound to a great degree, right? Mm-hmm. And they also are, they can be transitory. And there also is some question about identifying hardware versus identifying individuals who are operators of that hardware. David?
Yeah, I just want to jump on that because I think Jane's points are very important. And where I was going to with my comments was to say we've, I think, done a lot of work collectively as a privacy area of study on what the principles are. And I think if we look at the Article 29 Working Party's paper, recent paper on personal data, articulates extremely clearly and lays out a great philosophic framework of what can be for personal data. Well, I think there's an obligation now for those of us who design systems to apply those principles and that articulation and that philosophy to the systems that we're designing. In the way that Jane described, ISPs can design their systems to make their IP addresses more dynamic. We've seen a tendency now with people having broadband connections in their home that people's IP addresses may not change as frequently. That's something that the ISPs can control. People who are collecting the data can actually choose not to relate the data to other data, for example, that might lend it to being a little bit more identifiable. So it's understanding what the uses of the technology or the services are being and trying to design for the maximum amount of privacy protection as possible up front.
So if I've got this right, we've got safe harbor, we've got binding corporate rules, we've got model contracts, we've got the transfer using technical means of some identifying characteristics that may or may not be developing. We haven't talked about IPv6 yet, which means there will be a huge expansion of Internet Protocol addresses. That could cause more identity or more identifying characteristics. So there's a lot of complexity involved for large corporations. This is largely based, I think, on the adequacy standard that is embedded in the European Data Directive and is supported by the supporting member state legislation. Joe, what effect has this approach had on the development of standards in a broader than the US-EU context?
Well, taking a page from your fractured fairy tales, while Richard the Longtail...
Larry the Sailor?
No. While Richard the Longtail was actually off going east, Joseph the Traveler was heading west.
Yes. The nomad.
And by the way, Joseph the Traveler, when he complains to United, gets results. But he was sent on a quest by the Oracle at Redwood Shores. And his quest was on the tail of accountability. and the concept of how one achieves that quest. And it's by harnessing the global information force. Because the way that force flows informs us of how we proceed in these matters. And so I too had to, Joseph the Traveler too had to go and meet some of the masters of that domain, Richard the Eloquent, Malcolm the Good on You, and Blair the Red. And Joseph the Traveler was armed merely with the transborder map of OECD, and fortunately had the nautical charts of the PIPEDA. And just because I'm not sure everyone is as familiar with the Asia-Pacific issues as they are with the European issues, I'm going to end the story there. PIPEDA is the Canadian Privacy Act. The OECD guidelines, I'm assuming everyone is familiar with. As we go into the APEC region, and let me remind everyone that everyone thinks of APEC and they immediately think Asian. APEC is Asia-Pacific. So economies like the United States, Canada, Russia, all of the Latin American countries that have Pacific-facing coasts are part of APEC. So APEC is not just Asian countries. So in APEC, they started looking at a set of principles, which became essentially the APEC version of the privacy guidelines, which are in large part based on the OECD guidelines. The major change to the OECD guidelines, or the major differentiation, is in two places. One, there's an organizing principle within the principles, which is the principle of harm. It does not mean that harm is the exclusive things it looks to, but it means that in some ways, if you want to use a European term, there's a concept of proportionality based on harm that's built into as an organizing concept, not as a principle in an application, but an organizing concept. And secondly, accountability, which is the basis of PIPEDA as opposed to adequacy, and really what the difference there is that the obligation flows with the information. And if you're thinking about a point in time where you have a set of global information flows, where it's much less predictable because of the fact that service functions of companies are distributed internationally, that they are no longer linked in a geographic or a temporal fashion, because at 3 o'clock in the morning, you're going to pick up the phone and call customer service, and the phone is going to ring someplace where the sun is shining because that's the most cost-effective and logical place to provide the service from. And that solutions are going to be done in that fashion also, so that you have a 24-hour processing day with which to solve problems, as opposed to just an 8-hour window with which to solve problems. And that's the reality of the global information flows position that we're in today, especially as you get to the larger companies. But it's even becoming the reality for many smaller companies because they do work across a value chain that's global also. So when you look at that context, one of the things that APEC was looking at, they had two major problems that they had to face. There was no similar background of Western culture in a privacy culture within APEC that was in any way uniform across the countries. And there is a much greater variety of legal framework and cultural background across those countries. So the idea was whatever solution was going to work in APEC had to be flexible enough to meet those variations among approaches while being credible enough to give people a feeling that they had actually improved the state of play and they were actually doing something that had enforcement related to it. And that's where the accountability concept came in, which had been used successfully by the Canadians. And it was the idea that the threshold of where you start with a collection actually follows that information through. And then APEC has to develop processes, and we call them, it's a three-stage concept of a win-win-win. Because the whole idea is APEC had to bring something that was beneficial to the consumer, that was beneficial to the regulator, and that was beneficial to the company. Otherwise, this really wasn't going to work because everyone had to see benefit in the process. And the way it went forward was they created these privacy guidelines, which is now called the APEC Privacy Framework, which was adopted by the ministers and seconded by the leaders a couple of years back. And now they're doing an implementation program, and the code name for that in APEC is a Pathfinder. A Pathfinder means that part of, but not all of the APEC economies are participating. So at present, there are 15 APEC economies who have agreed to participate in the Pathfinder, which is broken up into multiple projects. And without going through the projects, the way the win-win-win scenario works is, let's say I have information that gets transferred. Starts, let's say in Australia, gets transferred to the US. Well, first of all, let's do the Australia situation. If Australia's collected, information is collected in Australia, never leaves Australia, APEC doesn't apply at all. Go to Australian law, that's the solution to everything. If you had a current situation where information was collected in Australia, and it got transferred to the U.S. Well, and let's say the transfer is from one company to an affiliate. Well, in theory, the Australian Data Protection Authority has remit against the Australian company that transferred the data out, because that company is within their jurisdiction. But if the other company is not cooperating, there is no remit to that other company because the transfer is outside the jurisdiction of the Data Protection Authority. They can request cooperation with the FTC, which happens on occasion. They can request cooperation through mutual legal agreements. That also happens. But there is not a de facto ability to extend that jurisdiction to that person with any effectiveness. The APEC concept is, let's create a set of rules that says, when I collect information in Australia, that information is collected with a certain type of limitation associated to it and what I can and can't do with it. And it might be further subject to further limitation because I may make promises to you related to that information. The idea is those conditions captured at the collection of the information, both as a result of my promises and as a result of the legal restrictions, are the obligations that get transferred with the information. Where business starts to see a benefit from this is it's the collection limitation and the limitations of the law of the country still exist. But what we're trying to iron out is the ability to transfer and use the information across borders, because now in this more global setting, we cannot predict where the information is going to be needed, who's going to need to access it, or what repository it makes most sense to put it in. If you want to build a top-level data center, it's going to cost you many millions of dollars to do that. You cannot afford to put one in every country. Therefore, if you don't have one in one country and you want to just keep the information there, that information is going to be kept in a less secure facility by definition, because you can't have that level of security in every country in the world. So in some cases, that centralization of information actually benefits the security of the information, because you're actually putting it in a place that is better protected than the place that it otherwise would be. And the more you can facilitate those transfers with an accountability framework behind them, the more business sees logical sense in how to organize the back end of its operations. So that's a benefit for business in that one. The benefit for the regulator is APEC also has an enforcement cooperation paradigm. Part of the concept is once an APEC paradigm is in place, and let's say in the United States what you'd be using is perhaps the FTC working in conjunction with a trust mark as the kind of enforcement body. Well, the customer would always be asked to go to the company first to see if they can resolve the problem. If they don't find a resolution in that space, they go back to their regulator. It might be useful if they were also willing to try the trust mark if that was easily accessible, but that's not necessary. Would be preferable, but not necessary. You go to your regulator, and then your regulator will either follow up with the trust mark, and if no result gets there, they'll follow up with the enforcement authority. So as the consumer, I don't have a different path of resolution. My path of resolution remains the same. And as the regulator, I actually have now a path of cooperation which didn't exist in a formalized manner beforehand. And that's where we get kind of the win-win-win scenario. And I know we're trying to make this interactive, so we'll perhaps leave other fleshing out for a little later.
I have a question. So we talked earlier about serfs and peasants and guild members. Consumers are fine. What about employees? Does this anticipate the same level of access for personnel data?
At the moment, it was Malcolm the Good on You who came up with the concept of, you first start with small steps on a long journey. And the concept was the first and most common problem that was being dealt with was essentially what was in the customer service paradigm of customer information being moved along. And that's really the first phase of what APEC is looking for as the pathfinder. The concept is if it can work in that context, you then start expanding the circle of the context you're looking at. So it is entirely conceivable that over time that will become the paradigm. In APEC, there is even less uniformity and in some cases absolutely no law whatsoever related about privacy in the employment space. So it's a little more difficult to cobble together a consensus on that because you'd have to actually start legislative action in so many countries in order to create a baseline.
Right. Right. So we've seen a variety of different solutions that are potentially useful. Some complicated, some emerging, some in experimental phases right now. wanted to just open this up now to talk about both the technological effect on these various kinds of arrangements, the approach of adequacy and the difference between an adequacy approach and more of a accountability approach, and also to think a little forward about a world where there simply is no point-to-point kind of, I gathered this, I access this, I understand this, and where data can reasonably be considered to not reside anywhere, really. There's no reason for, in the future, and even today, to think of data as being in a place. It could be anywhere. A record could be a packet that could be assembled on the fly, and those packets could be in any space on the globe. It doesn't really matter where that packet lies or where pieces of it lie. And that could be hugely helpful in storage and retrieval and access and a lot of things, but hugely complicating to the whole question of who has jurisdiction over the behaviors that are exhibited around that data. Panel members, questions to each other or to the audience, to yourselves?
Well, I just wanted to add one clarification, because by using the example of Australia, there wasn't the clarification that if you think about APEC, some economies have no approach to privacy at all yet laid out. Some economies have, like the U.S. approach, you have Singapore has an approach itself, Malaysia's taking an approach but hasn't created one. It doesn't mean that if you've got nothing to do with privacy in your economy yet, that that's the standard that gets written to. The concept is the various parts of the APEC study group get together and determine what factors are required. What they're not coming up with is a set of fixed things that are the only way you can do it. So let's take a look at the U.S. model I said. Perhaps you have something like the Federal Trade Commission who has the Article 5 power. You work in conjunction with a trust mark, which is kind of the basis of the safe harbor, and that is the way that you do the enforcement. Well, in Singapore, let's say the Consumer Protection Authority in Singapore was willing to play a similar role, but doesn't have the equivalent Article 5 power. So that in Singapore, for instance, a mere declaration doesn't get you power to do enforcement. Well, then you would need the trust mark, the Consumer Protection Authority, and then a contract that specifically granted the jurisdiction for the enforcement, because otherwise you wouldn't have the federal or the legislative backstop that's necessary. I mean, it's kind of interesting. We've used the term self-regulation in the United States for a long time. And in the vast majority of cases, self-regulation is regulation administered by a private sector body with a federal or government backstop of some kind. And it's not quite co-regulation because there's not necessarily a coordination in the drafting. But there is not a concept of it's the Wild West, and by the way, there's no one looking over your shoulder. So I think that's a clarification that is useful to make.
Questions from the audience? Peter the Tall.
Yes, all right. I would like to make 2 points. One is very short, and one addresses the issue raised by David and commented on by Jane about personal data. The short comment is, in terms of a workable jurisdiction, we have found that the place where data are is not feasible. It's irrelevant for the reasons you have mentioned, and this is why other criteria have been introduced so far, like who's doing this and where this person, and then, or where have certain things taken place, but the European directive starts from the presumption of the responsible organization where is it established. Now, as to personal data, I would accept most of what has been said, but there were some important details which did not come out, and in fact, it would not be correct if we speak about the European text to speak about IP addresses, whether they identify a person or not. Because the test is whether data relates to an identifiable individual. So the identifiability may well be based on something else than the IP address. And then, so that is an important difference we should not overlook. And to say more, it is identifiable for either the controller or someone else. And that is an additional complexity. I don't want to unroll the whole story, but that's a very important distinction. The second is, if we overemphasize IP addresses, we seem to ignore all the other data which are being collected. And the more you have about the likely candidate of identifiability, the more you focus on that person of flesh and blood, the more identifiable it becomes. Particularly if the essence of the activity is to get as close to the behavior you want to monitor for advertisement or whatever, the more reasonable it is to conclude that identifiability exists. And the third point is that we're probably faced with uncertainty at some point. In theory, you might say 53% is identifiable. We don't know about 47%, or things like that. We could argue whether the percentage is just for the discussion. So what conclusion follows from that? If a relevant proportion of your activity is covered, and an unknown proportion may be, but we don't know. My guess is that your conclusion is that you apply something like, we better be sure that the whole thing complies, otherwise we may at some unwelcome point have a problem. All these mechanisms now work together. And if we do not deal with a micro question like Mr. X or Mrs. Y is complaining about her or his data, but about does the system comply, then you think you're well advised to take the inclusive approach. And this is very much part of the debate we had in the European Parliament last week. This is what I wanted to make, because otherwise it's a bit slippery, and I agree with David's point that there is much more nuance, but for exactly that reason I wanted to bring these 3 points in the debate.
And it remains slippery. It's a difficult question. And certainly we learned from the AOL release of search results that search terms tied to an IP address could identify an individual and connect them to that IP address easily. And with narcissistic Googling, and everybody here I'm sure has at least once, if not more than once, Googled their own name, the daily recurrence of your own name in your search terms might be a clue as to who you are. So there are very significant reasons that IP address becomes a key, a record finder, if you will. Much like a database key records a record, that IP address can be in some circumstances regarded in that same way. And as such, any identifier that allows the retrieval of an identified record, and if that record contains sufficient information to identify the person, then is personally identifiable. Part of the problem is trying to comply with rules around personally identifiable information. I want access to my IP address. What is it? What do you mean? Well, I want to know my IP address. It's personally identifiable information, and so I want access to it. I want to see it. We're not sure who you are, and I don't know if I could give you access to that. We may, in some cases, be able to. We may not. And there's a very great gray area in between the two stages. So we have to become used to dealing with the advance of technology that allows identity to be, if not fully revealed, at least indicated in some way. And so we find that technology encompasses identity more and more every day.
And Richard, I think I wanted to address Peter's point. I think when I do classes internally for our executives and our marketing people who are designing programs. Often what they're doing is designing a program that they would like, or designing a new technology that they would like to roll out worldwide. So what they want to understand is what are the principles that I need to apply. And when I get through my presentation about the directive and then the differences in the member state implementing legislation and the U.S. approach and the different FTC actions and then PIPEDA in Canada and the approach in Japan, usually at least a couple of them are running from the room, muttering things about lawyers that aren't too complimentary to my profession. Now, and I think that, so designing a system so that we make certain that the entire system protects against risks for a portion of the system could be a result that we have to go to, or we should give guidance overall to organizations of where does the portions of the systems create the risk, and articulate some best practices for those folks so they can design their system. So you and I have had this conversation about RFID tags, exactly, where I get very concerned. We have a business where we go and we help people do RFID implementations in different business areas. And one of the ones that's most interesting is in the area of healthcare and with hospitals. There's some fantastic ways that hospital systems use RFID technology that save people's lives, make sure that they don't get the wrong blood type given to them, make sure that they don't get lost in the hospital. A lot of different situations. Creating the same rules for RFID in the healthcare situation for it's the same from retail supply chain, not necessarily helpful, I think, to getting us to where we want to be. I think the same is true for international data transfer. We need to figure out where really are the issues with IP addresses and articulate what are the best practices we would want to see from ISPs, from website services that collect them, from the technology developers that create the technology that transmit the IP addresses, and I think, and get some sort of understanding. I think trying to find worldwide consensus on a lot of these things is going to be increasingly hard, but if we can at least articulate where the approaches where we can mitigate the risk, I think it would help a lot.
It's somewhat similar to what we did after, or what the U.S. government is looking at and what California has done with respect to data breaches. You know, what data is going to be the most, if there's a loss or there's a breach of data, when is it necessary to notify your customers? It's not the entire subset of data that would actually identify a person, that could conceivably identify a person, but it's actually data that could be tied to a person. And so, and I agree with David that we need to look and talk about these different types of identifiers and put rules around them based on the risk, and not the actual risk, but you know, it has to be a slippery slope, because if you take an IP address and you're required to attach all of the data protection principles to it, as Richard said, if we have a customer who says, I'm IP address so-and-so and I want to see all my search queries, number one, we can't do that right now. But if someone does do that, how do we know that they are that IP address? And it's not someone who's, you know, husband, they're in the middle of a divorce proceeding and he's trying to find out what his wife was up to online. I mean, how are we to find out that he was actually using that IP address, that they're who they say they are? So then you have a privacy problem there. So, you know, that's why I do agree that it is a slippery slope and we need to think about principles around this.
And that's what makes this hard, is that we like to have our own safe harbors where we know we're safe if we handle data in certain ways. And this is a field where the data that may be relevant is constantly evolving. And, you know, we're better served in an environment where you can deal in terms of proportionality and sort of do the right thing, as opposed to having a black and white rule like California's has been, where you have to give breach notification if you have these three combinations of data elements. And that just doesn't allow for the evolution of what's relevant data.
Michael.
I would submit that there's also a huge responsibility of technology companies to educate consumers about the issues that we're describing. And speaking with a brief vignette of personal experience, I bought a Microsoft Press book on Windows Vista for my new Vista machine. And in the glossary, it says that an IP address is a 32-bit address. The problem there, of course, is that Vista ships with Internet Protocol version 6 on, which is a 128-bit address. And it took hours and hours for me to search the Microsoft website to learn that, fortunately, there's a default off on the auto configuration of the interface identifier, which is the 64-bit last part of that address. But I, as a user, if I want to do peer-to-peer networking, have the ability to turn on an auto configuration of that address. And what that means is my 48-bit MAC address becomes my 64-bit interface identifier, which is globally constant and unique.
Simple enough.
I beg your pardon?
Simple enough. What's the problem?
The problem there is consumers do not know that if I want to do peer-to-peer networking with you, Richard, and I leave my machine with that auto-configured interface identifier, I'm telling Google if they can capture in their system a 128-bit address, a lot more than they're getting where I'm blocked by network address translation. They're getting a globally unique number for me every time I use my machine.
Yes, hence the IPv6 problem. As we,
and consumers
it
don't
will
know
explode
that.
In terms of the number of available addresses, and as a result, it'll be a much more convenient handle in order to have a persistent address. And the question is, of course, user control. And as you explained so clearly, user control is simple. No worries, huh?
A couple of buttons, I believe, but users don't know that. And with social networking, when people find out they can do peer-to-peer V6 communications, that's going to be cool.
And as we heard earlier, should users know that? In other words, is the burden that we place on users an appropriate and reasonable burden to control their own information? And only sane people could actually say, that burden is beyond it's only sane to say that burden is beyond any reasonable consumer's ability, and even the machine's ability. I mean, I'm glad to hear that Vista worked for you, but the problem really becomes not only, you just don't want to manipulate your system software that hard. You just want to, it's like a car. You want to get in, you want to go somewhere. Period, end of story. So the question becomes, what are the defaults set at when you receive it? And are they protective? And have you any understanding whatsoever of how to change those defaults to heighten your protection, lower your protection? What protection? You don't know. It's very, very difficult. When it comes to international transfers, that becomes significantly harder, because then you have cultural issues that come into play as well, where people in different cultures have different reasons to want to protect themselves, want to keep secrets or reveal themselves or whatever. I mean, may I ask, the social networking phenomenon in the United States, we'll just pick on MySpace, Facebook, and YouTube as one. Is this an expression from other cultural points of view of pure cultural insanity in the United States? Or is this something that you will see also, is it rising in the European Union as well? This self-publishing, it's all the same.
It's also developing.
Yes.
In fact, the consequences of what we have been saying for social networking are presently in discussion. I mean, the work plan, the 29 group in the next year will likely cover this. And it will also be a subject where some discoveries will be made about needs we have for the future, obviously.
And it'll be amazing.
Yes.
So as we We have talked about how entities are collecting and transferring and accessing information. Great. Hard. Very difficult. Very complicated. What happens in the next 5 years when the amount of information that's transiting different jurisdictions is not controlled by entities? It's people. It's individuals. I mean, I don't know about you, but I was Person of the Year, Time Magazine, for just recently. And the whole question is, if you define the content and you distribute your own content, you are becoming your own data controller as an individual. Now, will you sign a model contract with yourself that says that you will act in certain ways? Will you sign up for the Safe Harbor program with Damon? Will you, as an individual who, whatever, has your blog, has your video, has your music group, has your whatever, will you be the one who's required to act in the way that we are requiring organizations to act, to be accountable for that data and that distribution, particularly across multiple jurisdictions?
I mean, one of the interesting observations that you have in the social networking phenomenon is that the people who are most aware and most literate in the technology are the people who are choosing and who understand the ramifications of what they're doing, of posting all this information fairly publicly. And one of the major downsides and problems is, one of the reasons they're doing it is they're probably 18. And if you remember back to when you were 18, well, heck, silly decisions were something you did as a matter of course. It's part of the definition of being 18.
So, Joe, I would agree with you that they're choosing to do so. I'm not sure I would agree with you that they understand the consequences. I don't think a teenager understands someone younger than that understands the consequences of potentially falling into the hands of a pedophile. I don't think somebody understands the consequences of their college admissions officer reviewing their website and declining to admit them to college based on what they put there. I think we've got a failure to educate the people who are participating here on what the consequences of their decisions are. I have 2 young boys, and the thing that I find myself saying in the house more than anything else is, that life is about trying to make good decisions and learning from the bad ones that you make. You can't do that unless you understand what the consequences are. I'm not really sure we've educated the people using the technology on that.
I don't necessarily, I think when you get to younger kids, I think that's especially true, especially because I don't think they understand as much as that there may be harmful people online who may use some of this information, and I think there's still a tendency to think that you're somehow speaking with your friend and not being observed by all these other people who can observe you. But I remember in the Montreal Data Protection Commissioners Conference, there was a panel on these technologies, and they were asking and interviewing their students, and they were saying, well, what do you do? And the answer was, and a lot of them were on public sites, and what they were doing was providing false information on the public sites. And someone asked them, why are you providing false information? And one of the kids had the greatest answer: to stick it to the man was the answer. On the theory that, they were actually understanding why the information was being used and how it was being used, and they were selecting when to provide information that was true and when to provide that it wasn't. I think they understand the theory of the fact that a college guidance counselor or an employer may see this information. They're just not paying attention to what the consequences of that may be. And I agree with you, that's an education, but that education, someone said companies need to do more to do that education. They're not going to buy that education from companies. It's going to have to be through some kind of, combining peers and educators and, kind of messaging. Because from a company perspective, it's going to look like, what does that mean?
So we open the day with this discussion around notice and choice. So I'd like to ask Fred the naysayer to comment on how this circle kind of gets completed.
I'm still back to the idea that these teenagers are making informed choices. How many adults make informed choices? So what makes us think they're making informed choices.
I turned 18 in the late 60s. I have no recollection.
But I think this discussion has really highlighted much of what we've been discussing during the day, which is a lot of this is a question of where does the responsibility in the long run lie? In other words, what is the relevant role of different national regulators? What's the relevant role of individuals? What's the relevant role of companies? What's the relevant role of educators and researchers? And to some extent, I think what we see is a certain amount of kind of, ships passing in various ways that aren't always on even parallel, much less intersecting courses, so that we, in a regulatory sense, have relied very heavily on certain types of tools, notice and choice being among them, certainly in the U.S. environment, which, as we've just heard, it's hard to think of any of these issues over which we would expect individuals of any age, other than you, Joe, to make intelligent, informed, thoughtful decisions about how this is used, especially as we get more technological, more power in the hands of individuals. And we talk about this a lot in the security area, and I keep thinking security has a good analogy here. That the installer comes in, or you use your 12-year-old kid, whichever, and hooks you up to a broadband internet connection and walks out, leaving this thermonuclear device in your house with no instructions, no firewall, no software, nothing. Well, that's where we are with data. Great. Okay. Be careful what you wish for.
He didn't disappoint, did he?
No, he didn't. Perfect. The issue has been mentioned here that it should be about consumer education, and that we have too stupid a consumers to keep up with the technological advances and the speed of data transfers, collections, and uses. So how many companies and how much money has been spent on consumer education around this issue? Okay, that's about right, about nothing. Just about, because it's inordinately expensive to do.
Actually, we just launched a privacy channel on YouTube, and we just launched a third video, and they weren't free. So
hey,
we
right.
have spent some money.
The Federal Trade Commission has done a lot of work. They've invested a lot of money on user education. I commend their site to anybody to look at, but it isn't the kind of $100 million advertising campaign that needs to reach people. Yes?
I would contend that the problem is not user education, because it has been out there. I don't know if anybody's seen the program To Catch a Predator, and well, that was done in my hometown, the town that I just moved away from. And so
good place to be from.
Yes, and so the education has been out there, but I believe that make an argument that it's not consumer education, but it's just consumer apathy. And so we can make a parallel with smoking. There's been billions and billions and billions of dollars spent on education about smoking, yet people still smoke. And it's just as dangerous to you as data privacy.
Just as addictive as the internet, too.
Yes.
Okay. Comments?
Yeah, Fred, it seems like you've affected our moderator and gotten him into a very negative. But I'm not there.
Not easy to do either.
Yeah, I know. I'm not really there.
Back to the 60s.
Yeah, indeed. I think this day itself is a sign of progress. I think the commitment that a number of companies, many of whom are here and are sponsoring Privacy Day, Oracle, Google, Procter & Gamble, Microsoft, to come together and try to get into schools and do education. The commitment and resources that we see from the companies that we work with to try to build technology that safeguards people's data is staggering. I wouldn't want to leave people with the idea that companies are not working on that. Do we have challenges? Absolutely. Is education alone going to get there? I completely agree with Fred, but I don't think we're relying on education alone. I can share this because it's been public. We've had meetings with Microsoft where Microsoft has said, look, we can't give everybody a choice about every single feature in Microsoft software. At some point, we have to design it to be secure, to protect people when they use our product. I think that's an incredibly responsible approach as a company, even when it creates difficulties for them, expense, usability issues, but they understand that that's an issue. I think more companies are taking that approach. I think if we can articulate what the best practices are from an international perspective to give better guidance, I think we'll see even more do so.
Yeah, I just would add that data security itself is actually a space where I don't think we see that much divergence internationally between expectations. If you, in the countries where you do have data security expectations and laws, they're not that different generally from what you see here in the U.S. So I think we're sitting in the same pew generally on that. Companies like mine and others I see in this room spend a tremendous amount of money on the security aspect. You hear discussions here and there. The banks can afford a certain level of fraud and we just sort of manage to it. That's not really true. I mean, there's a tremendous amount of effort that goes into protecting the data because we have found, unfortunately, that consumer education has very limited effect to date because I think, as you said, it's consumers have a lot of things to think about and there's a certain level of consumer apathy.
Right. And you don't need a license to use a computer to go on the internet, so there's no testing involved. That's one of the things, too. So it seems like from today we've gone from this notice and choice concept around to this idea that it is enormously complicated and there are ways that are developing that entities have a sense of accountability and they're struggling to figure out how to live up to that accountability through transparency, through proportionality, through minimization, keeping in mind that one of the best ways to retain the least amount of data is to not collect it in the first place. The point, I think, of the day seems to be that a culture of privacy and security is not something that just can be implemented and Deus ex machina just dropped down onto the planet. We are developing it slowly. We're developing it in a way that may not seem as rigorous as some people would like, but it is, I think, substantially developing. And it will keep up with technology only in the sense that technology will continue to drive and thrash this thing to force us to keep up in policy. I welcome all of the students here that are participating. If any of us who are a little bit long in the tooth and gray in the beard have had this kind of an immersion earlier, I think we probably would have solved some of these problems a little earlier too. This is very heartening to see the kind of participation that we've seen today. I want to thank our panel. I want to announce that after Leonardo the Younger's dismissal, we will all be hosted by Wummel and Carlisle to a delightful reception in the immediate antechamber to the auditorium. Thank you all very much, and thank you very much to my panel members. Leonardo. Leonardo the Younger.
Okay.
Sounds great.
It's been a long day. You are all exhausted, as I am. I think I would only like to say three things very quickly. Some words of gratitude, which are due. Some words about Data Privacy Day 2008, the things we have accomplished. And finally, a short but lovely story about data protection in the 16th century. This is not technological, but still interesting. First of all, I would like to express my gratitude to Sharon Peters, is she here? Well, you tell her that I said that, because she organized a wonderful conference and has done a really remarkable job. Also, I would like to thank the European Center of Europeans, the European Center of European Studies, the Center of International and Comparative Law, and the Law School for providing for this venue, and as well as the funding that has made this event possible. Thanks in particular to Francesca Vignami, that, as you all know by now, is one of the best, if not the best, worldwide specialist on the issue of data privacy in transatlantic perspective. Thank you very much as well to David Hoffman, who has been the shadow coordinator of Data Privacy Day, Jolene Deringer, who has prepared an amazing presentation for teenagers, which is really remarkable, and Marianne Bella, my assistant with the media and outreach, who has been really committed to this Data Privacy Day. And thank you to all speakers and moderators for a wonderful conference, and thank you all for staying here until this time. I think this data privacy or data protection day we had today for the first time in America, I heard some criticism from some people saying we should have Freedom of Information Day in Europe sometime. I never meant to approach this from this perspective. I always had the feeling and the sincere belief that there's no reason why the United States should not join Data Protection Day, because you have data protection legislation, and therefore there is no reason why you should not celebrate data privacy as other countries do. So that's the only reason why I came up with this idea. And I think the day has been very well. I don't know how it went in Europe. I still didn't talk to my colleagues, but here in America has gone very well. We had this amazing proclamation by the governor here in this state declaring Data Privacy Day, which is really a signal for all of us. And we had Vice President Frattini saying some words to all of us. And I think this is really a clear signal of the importance that data privacy is having for the 21st century. And I'm very glad to say that Data Privacy Day has not only been a thing here in North Carolina, there have been many other activities in other states. We have had at least presentations by IAPEC members in the following states: New Jersey, New York, Nebraska, Colorado, California, Minnesota, Ohio, Seattle, Miami, Virginia, and Indiana. In all these places there have been activities. Some cases have been academic activities, some cases have been talks in high schools. In all these places have been some Data Privacy Day activities. So I think we have managed to light the torch for many more Data Privacy Days in America, and I think that's fair enough to be said. And to finalize, as I promised, this short, lovely story about data privacy in the 16th century. The historians debate long, extensively, who has been the most powerful man on earth. And there are many theories, but I do believe that the most powerful man on earth was the Spanish king, Philip II, because he ruled with absolutist powers, a vast empire who really extended across 4 continents. He was so powerful, this man, that it was so rare for people to meet him that it is reported that most people meeting the king were really shaking. So nervous they were. So the king used to start all meetings by saying, "Gentlemen, calm down, calm down." Caballeros sosegados, sosegados in Spanish. And in certain occasion, the king wanted to recruit a young man, a young person, to join his personal staff. So he sent a letter to the provost of Salamanca University, inquiring about the details, the private details of this student there. So he asked the provost, is this, or was he a religious man? Did he regularly go to mass? Did he gamble? Did he had any affairs during his years in the university? But the provost's answer is still kept in the archives in Madrid. His Majesty, the provost said, you asked me about private and intimate details of one of my students, and with all due respect and loyalty to His Majesty, I'm afraid that I cannot provide you with an answer. There is a well-known principle of natural law that says that these private and intimate details belong only to that person, and even His Majesty is bound by these principles of natural law. So the king made no further inquiries and hired the young man. Happy Data Privacy Day.